Cracks in the foundation are beginning to show, and it should come as no surprise. Welcome back to Midas Touch Legal AF. I am Alex Aronson with Court Accountability Action. Thrilled to be with you here again to talk about fast-moving developments in the breakdown of our constitutional order. And in the face of this shock and awe campaign against our democratic system by the Trump Doge administration, many Americans have been looking to the courts as one of the last remaining institutional guardrails against autocracy. And so far, they've been pretty good at holding, particularly in the lower courts. District courts and courts of appeals across the country have put important pauses on many aspects of this administration's unlawful agenda. But now these cases are starting to make their way to John Roberts' Supreme Court through the so-called shadow docket, the emergency docket. And that's where the cracks in this foundation are really starting to begin to show. Just a few weeks ago, as Trump and his MAGA allies howled in outrage over the lower court judges who were ruling against them, demanding their impeachment and effectively threatening violence against them, John Roberts took the unusual step of standing up for those judges and saying, this isn't how we do things. If you have a problem with this, take it up on appeal to us. And there was a debate at the time about what that signaled. Was he actually standing up for the rule of law and the independence of these judges? Or was he sending a message to Trump and MAGA world that actually the court is with you on this stuff? You don't have to worry about it. And in some of these cases that the court has begun to resolve in the context of federal funding freezes around USAID, or the order allowing the administration to resume the firing of federal workers, Trump has found out that he actually may indeed have an ally at the court in John Roberts and his buds. And perhaps no set of cases is more important to understand this dynamic than the immigration cases that are currently up before the court, and where the court is reviewing the administration's pretty blatantly unlawful, unconstitutional removal of hundreds of immigrants here in the country on the grounds that they are alleged gang members from Venezuela. They were picked up in the dark of night and shipped off to a mega prison in El Salvador, known for its torture and abusive practices. So to dig into this, I'm thrilled to be joined by my friend Scott Shuchart. He was the former director of policy at Immigrations and Customs Enforcement under the Biden administration. Scott, thank you so much for joining us here on Midas Touch Legal AF with Court Accountability. Give us a read on what's happening. This is a fast-moving set of cases. Of course, Boasberg, ordered a plane return. The administration defied that order. Where do these cases stand now? We're taping this on Wednesday morning, so there might be developments before this comes down. But how are you looking at what's happening in these two important cases?
Yeah, thanks. No, this is fun to get to talk to you about all of the outrage that otherwise we're just looking for other places to take. There are two cases arising out of those Alien Enemy Act flights that have been at the court. One was decided yesterday. The other one was involved an order that was supposed to be effectuated on Monday, and we're still waiting to see what's going to happen with that. So in the first case, JGG, this was the case about the Alien Enemies Act planes. As you said, there was supposed to be a hearing today at 10 a.m. on whether there would be permanent or preliminary injunctive relief in that case. That got scrubbed by Judge Boasberg because last night the Supreme Court held that those claims had to be brought as habeas corpus cases. The upshot of which is they have to be brought in the district where the people seeking relief are confined. And not coincidentally, but conveniently for the administration, most of the immigration detention facilities are in Texas and Louisiana in the Fifth Circuit, which is far and away the most right-wing dominated of the circuits. Of course, it's the circuit that the Supreme Court has been reversing the most as well. It is out of step with the temperature of the Supreme Court a lot of the time. But the idea is that those cases, to the extent that they can be brought in the future by other ICE detainees who are seeking to prevent their removal under the Alien Enemies Act, well, those are going to have to be brought in front of district judges in Texas or Louisiana, or so it seemed. Now, it's not clear when the Supreme Court says that these cases have to be brought in habeas, what that means for the people who are already in Venezuela, where they will have jurisdiction to bring a habeas. It is unclear whether Judge Boasberg has continuing jurisdiction to look into whether his temporary restraining orders that have now been vacated were willfully violated by the government in not turning those planes around. Within a couple of hours of the Supreme Court's ruling that Judge Boasberg's TROs were invalid because they'd been issued under the Administrative Procedures Act and that the litigation would sort of have to start over, maybe in Texas, as a habeas case, the ACLU filed a habeas class action in the Southern District of New York. There's a hearing on that going on right now, I think in front of Judge Hellerstein, who is a very hard-edged, assertive, long-serving judge on the Southern District. And I don't know which way that's going to go. There's not a lot of precedent for habeas class actions, but as I think it was Justice Sotomayor's dissent pointed out in the JGG opinions that came out from the Supreme Court last night, um, if you don't have a class action, the idea of hundreds of Venezuelans who are in detention, all of them needing to find counsel, all of them needing to articulate individual claims about what is essentially all the same question, whether a law passed in the John Adams administration that's only ever been applied and that says it can only be used in times of declared war could be used against a small Venezuelan street gang. Why would you litigate that 800 times in front of every federal district judge? So maybe the class action in front of Judge Hellerstein is going to be the answer. That's a long-winded answer, and I haven't even gotten to the second case, which is the Abrego case. And that is someone who was on the third plane of those three flights that went to the Salvadoran prison. That was the flight that was not Alien Enemies Act removals, but other removals. The problem with Mr. Abrego is that he had withholding of removal against the government of El Salvador. It was illegal for the United States to remove him to El Salvador. It was also illegal to remove him to anywhere without an opportunity for him to contest that. They didn't follow the right procedures under that at all. And Judge Paulicinas in the District of Maryland had ordered him returned by midnight on Monday. The government has been fighting that tooth and nail into the Supreme Court. There was a briefing on it into yesterday afternoon. There was another brief filed, short brief filed by Mr. Brego's lawyers this morning. And any minute now, we could hear about whether there will be action on whether the government can be obligated to take its best steps to bring Mr. Brego back, since his removal was so clearly. And the government admits that it was an error. They don't, I think, admit that it violated the law or treaties, which it does, but they admit that it was an error. And the question there is all about whether there's any remedy available.
I think that's so important, right? The acknowledgement of the from the government that this was an error, right, and a reflection of just what a broad brush they are painting with as they, undertake what I described earlier as part of a shock and awe campaign to instill fear and terror in immigrant communities. They're not doing this with any type of tailoring. They're not doing their due diligence to make sure that the people that they're sweeping up are actually a danger to their communities. They're not checking, in fact, whether the people that they're picking up have orders of withholding of removal, as Mr. Garcia does, and they're just letting it happen. And meanwhile, even as the court sort of lets the Trump administration do this, they're still saying that folks that the administration wants to subject to these types of removals are owed some due process. How can they sort of reconcile that with the facts on the ground about how this administration is undertaking these policies, right? Undertaking
Yeah.
this implementation? Where is the due process in reality? Is it just a pipe dream that they are kind of invoking to look like they are being a court?
Yeah, it's very much a shoot first, ask questions later type approach to immigration enforcement right across the board, and it has been since noon on January 20th. Justice Kavanaugh has a dissent trying to stand up for the idea that habeas has always been the way that you deal with these things, but it is unprecedented for people
Was it a
to.
concurrence or a dissent?
Sorry, it was a concurrence. Thank
Yeah.
you. A concurrence with the per curiam. Uh, It is true that individual cases with individual facts should be individually adjudicated. We are seeing an unprecedented degree of sidestepping ordinary processes, right? There is an ordinary removal process. And in fact, so far as we know, everybody the government has tried to remove under the Alien Enemies Act was already in ordinary immigration proceedings, where it would be clear what the due process would be, from an immigration judge potentially up to a circuit court. By channeling all of that into district court habeas actions, it is as much a fiction as anything that the courts courts are prepared to deal with that. And yes, you can point to a case in Blackstone in 1642 that is analogous, but the entire population of the Western world was smaller than the population of the United States in 1642, right? Like the scale just is not reasonable. And that's why for hundreds of years, right, Congress has created class actions. Congress has created multi-district litigation. There are lots of tools that are supposed to exist so that not every poor person arrested on the street in front of their autistic 5-year-old has to find a lawyer and litigate in federal district court. And the Supreme Court clinging to the idea that, well, that's why we did it in 1642, so it's the only way, is completely unrealistic.
Yeah. And of course, this is all against the backdrop of separate attacks on the legal profession to chill the participation of lawyers in representations exactly like this. And moreover, against the backdrop of a judiciary that is crying to Congress about a judicial administration crisis, right? The lack of enough judges to handle caseloads. And that seems to go out the window when it comes down to effectively rubber stamping a agenda from Stephen Miller and from Kristi Noem and Donald Trump that is going to require apparently individualized assessment of each of these habeas claims. What do you think, Scott, of that actual legal question, though, about putting aside whether or not this class-wide habeas relief might become available through the ACLU's lawsuit, about the court's determination that only habeas should be available in resolution of these types of claims?
It doesn't make any sense for the simple reason that none of them were detained pursuant to the AEA, the Alien Enemies Act. They would be detained even if they hadn't been removed because they were all in detention under ordinary immigration authorities. What they're seeking review of is the administrative question of whether they are entitled to process before being shunted out of that immigration process and over into a different process. If the Nuclear Regulatory Commission decided tomorrow to seize regulatory control of wind farms because Donald Trump thinks that wind farms cause cancer like radiation does, you wouldn't go into habeas with your nuclear plant to claim that you're being subjected to the wrong legal regime. That's a standard kind of APA question. And the fact that this concerns people who are in custody, it doesn't seem to me should change that. Now, this isn't a constitutional question, really. This is a statutory question about whether the sort of election of remedies concepts that surround habeas apply here. But just logically, it doesn't work. If they had won everything under the APA, nobody would have been released. They would have remained. Suppose the plane had been turned around, or the government had done the right thing once it knew that the case was live with Judge Boasberg and had never let the planes take off, right? Nothing in this case to this point, nothing in the entire complaint would lead to release. It would only be about whether people get final immigration orders before they are removed. And so the idea that that can uniquely sound in habeas, it doesn't make any sense to me. And I thought Judge Boasberg was very strong on this, and I thought that the DC Circuit, there were two. Somehow the DC Circuit wrote 100 pages on this, right? Like 3 days after they heard oral argument.
And it was a
And the
panel
two,
that was not like a liberal woke panel, right? Karen Henderson, one of the most conservative judges on the DC Circuit, joined that too on opinion.
yes, and I think they got that right. Now I will say, and you alluded to this as well. This was not a complete loss for the plaintiffs and the ACLU because, in saying that everything had to go to habeas, the Supreme Court was very clear that the habeas review has, however impractical it may be, that it has to be meaningful, that there has to be real notice, and there has to be a real opportunity to act on the notice that you're being removed under the AEA and get into court with that. And I think some of the government's representations to the DC Circuit that if the DC Circuit reverse Judge Boasberg, they would be putting people on planes instantly without any opportunity to pursue habeas, were really offensive to everybody. And I think that if the per curiam opinion had even just given more lip service to how outrageous that was, it says that it can't be the rule going forward. But one of the two parts of Justice Sotomayor's dissent that Justice Coney Barrett concurred with. It's a little bit unclear how much of the per curiam Amy Coney Barrett is signing on to. But I thought that if just a little bit of Justice Sotomayor's dissent had been in the per curiam, saying rushing these people out is unseemly, even if the government's position is there has to be a habeas, the habeas opportunity has to be meaningful. I think the per curiam would have had at least 6 votes and maybe seven, because Justice Kagan didn't write anywhere. Because that really is what was so of a piece, as you say, with other ways to undermine the courts, the rule of law, and the ability of law firms to participate. And then one little footnote: Quinn Emanuel, big litigation powerhouse firm that has caught some flack, and I understand correctly, for having been one of the firms that was putting pressure on Paul Weiss and trying to poach some of its clients, is the counsel of record along with the ACLU on this habeas class action. So even the firms whose conduct has not been sterling in fighting the Trump administration are finding ways to stand up, and I think they deserve to be applauded for that.
Thanks for flagging that. Where do you think this is headed? I mean, this isn't the only case now that the court has resolved through its emergency docket. We've also seen the court let the Trump administration proceed with its firing of federal workers. We've seen it step in to overturn a district court temporary restraining order that would have that was freezing federal contract spending. So they've allowed the administration to proceed there. So, it seems like the early wins in the lower courts are starting to, weaken themselves as we get to the Supreme Court. Where do you see this one headed?
I think that the government is going to let this one play out because ultimately the AEA was never an important tool for them. There's a declaration early in the case in the district court suggesting that there are only a couple hundred Tren de Aragua members left to be removed, and it is not infeasible to just remove them the normal way. This use of the AEA, with the president signing the proclamation one day and them hiding the ball until the last possible moment, even though the law requires it to be a public proclamation, this was all about shock and awe, right? This is all about showing strength and showing creativity, not about really solving the problem of the fact that the immigration court system is under resourced, the entire enforcement system is completely inadequate to accomplishing what Trump wants to accomplish. And so I think they just kind of pocket this win and let this play out. And if they never get to remove anybody else to Venezuela under the AEA, I don't think anybody cries over that. I think that they won what they wanted to win, which was to show that they were using unconventional tools and to own the libs and to stick it to the ACLU a little bit. Now, if Judge Boasberg actually orders contempt sanctions because of the way his order was defied, I think that comes back up to the court. I think the court is in a tough spot. And I think that, Judge Boasberg and Judge Kavanaugh, I read in the Washington Post, are basically best friends. Justice Roberts, as you noted, stuck up for Judge Boasberg when Trump was saying that he should be impeached. I wonder if this case kind of bifurcates in a way where there is some remediation for the past bad faith, just not in a way that helps anybody, right? That there's some kind of nominal sanction imposed against DOJ without anybody ever actually getting back from the prison in El Salvador.
No, it's a thorny mess. There's real world suffering, right? This is a guy who's in a freaking mega prison known for its torture practices. Scott, it's so important to have experts like you spend the time, being willing to come and break this stuff down for folks, because I think so much of it is designed to be inaccessible, hard to understand. And the disconnect between the complexities of these legal questions and the real world suffering that results from these policies is enormous and gives cover to this authoritarian agenda. And unless we continue to try to break it open to help continue to broaden public understanding of what's happening, how illegal it is, what the political dynamics behind these issues are, they're going to be able to continue to come up with creative attacks on the Constitution, on the rule of law. And so this, I think, is important in the first 3 months here, important indication of what's to come. And I can't thank you enough for your expertise, for joining us here today. Everybody, thank you for joining us here
Thanks.
on Midas Touch Legal AF with Court Accountability. Make sure to hit the like and subscribe button. We are growing this community. We are digging into the weeds of what is happening to bring you straight into the expertise that you need to help process these challenging times. So with that, I'll sign off and see you next time. Thanks so much.
In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.